Hi, good morning, everyone, or good afternoon, I guess, for those on the East Coast. We are excited to be here today for our webinar on Inflation Reduction Act opportunities for early stage entrepreneurs. My name is Molly Melius, and I'm the director of Stanford's Lawyers for a Sustainable Economy initiative, which is putting on the webinar today, along with some help from Emma Hutchinson with the White House Office of Clean Energy Innovation and Implementation, and a team of clean energy tax law experts and startup law experts from Wilson Sonsini. You may notice that Emma is not Karen Skelton, who was on the docket for today. Unfortunately, Karen had a conflict come up, but we are thrilled to have Emma with us. So before we get started, I can already see some folks putting things in the chat and the Q&A. The presentation and panel discussion portion will be recorded, but not the audience Q&A. Please submit your questions in writing to the Q&A function, and we will respond to those when we get to that portion. We will share the slides and the recording after the webinar. I've gotten lots of questions about that, so we will share that out. But again, the Q&A portion will not be recorded, so that part is only available if you're here with us today. Just a quick disclaimer, the Inflation Reduction Act regulations and guidance is unfolding all the time. There's new things coming out, so things are always changing, and what we're talking about today is subject to change. And if you need legal advice, you have to consult your attorney and maybe some attorneys through this pro bono initiative that I'm going to describe today. So our goals today are twofold. One is to help educate and answer questions for startups engaging with the Inflation Reduction Act and how to take advantage of some of the new opportunities there. And the second is to provide information for early stage entrepreneurs about how to get pro bono help from law firms in the Lawyers for a Sustainable Economy initiative. Lawyers for a Sustainable Economy initiative supports tribal communities, environmental nonprofits, and early stage startups working on sustainability projects or hoping to access Inflation Reduction Act opportunities. We connect those entities with law firms who are in the initiative. We have 17 law firms in the initiative right now, and we've helped over 120 startups and nonprofits over the last few years. The initiative was actually launched back in 2018 by Karen and a few founding law firms, former Governor Jerry Brown and the former California Attorney General. And today we have Emma Hutchinson joining us. She is a communications advisor for the White House Office of Clean Energy Innovation and Implementation, as well as a speechwriter for John Podesta. Emma previously served as a speechwriter for Secretary Jennifer Granholm at the Department of Energy for 2 years. And before joining the Biden-Harris administration, Emma was a senior associate at Climate Nexus, where she helped develop communication strategies for the climate movement. And she did a fellowship as well at the MacArthur Foundation, where she contributed to their climate strategy and grant making. After Emma's remarks, the Wilson Sonsini team, pictured here, who collectively have decades of experience in clean energy tax law and startup law, will be presenting additional substantive content on the Inflation Reduction Act, holding a panel discussion, and then answering any questions you have in the audience. You'll hear a little bit more about the Wilson team and a little bit from Jaren, but for right now, I'm going to hand it over to Emma.
Thank you so much, Molly. As a Stanford alum, I am so excited to see the Stanford Law School leading this really important effort. As Molly said, I'm on the team at the White House that is implementing the Inflation Reduction Act. Our team is led by the wonderful John Podesta. I'm very honored to work for a president who truly understands the seriousness of the climate crisis and the fact that it is already here. We just experienced the hottest summer on record. 98% of people on the planet experienced higher than normal temperatures over the past few months. And it's why President Biden passed the Inflation Reduction Act more than 1 year ago. That law makes the largest investment in climate action in history, not just in the history of our nation, but the history of the world. And as you all know, perhaps the most impactful tool in that law is the 10 years of clean energy tax credits that it establishes. That means 10 years of policy certainty for clean energy. That's unprecedented in this country. Before, you had to wonder if those credits would be extended every 1 to 2 years. And so now that we have 10 years, companies can plan long-term. They can innovate. They can think big. And that is exactly the response that we've already seen from the private sector over the past year. More than $115 billion in clean energy manufacturing investments, more than $120 billion in clean energy generation announcements from utilities. It's truly a fantastic response, but we know that we have to keep going. In order to tackle the climate crisis, we need to fully unleash American innovation, and that's why I'm so excited about what you all are doing to engage multiple sectors of the economy, make sure that they can take advantage of all that the Inflation Reduction Act brings to the table. And again, speaking to the entrepreneurs in the room, this is where all of you come in. There are so many tools in the Inflation Reduction Act to help early stage entrepreneurs jump into clean energy, grow their businesses, and direct pay and transferability are two of those very important tools. So you'll hear from the experts a little bit later to learn more about those provisions. But I just wanted to say that at the end of the day, President Biden and Vice President Harris are working to build a clean energy future that reaches every single American. Creating good paying union jobs, and of course, protecting the beautiful planet that we all call home. So we need your help to build that future. It's going to take all of us. So thank you all for being here and for your engagement, your ingenuity, and our administration is here to be your partner. So thank you so much, and I'll pass it over to Karen Goddard.
Thanks so much, Emma, and thank you everyone for being here with us today. This is a topic we care a lot about. I'm really excited to share some of our thoughts on it. But before we do, we'll start off with introductions of the Wilson Sonsini team that's here. I'll go first. My name is Karen Goddard. I sit in our Seattle office. I joined the firm most recently, actually from Capitol Hill, where I was my home state senator, Senator Patty Murray, her chief counsel and climate policy advisor. So I had the sort of once in a lifetime opportunity to actually be on the Hill while the IRA was being negotiated. Of course, while I was there at the time, it was BBB. And it was very exciting to see that get across the finish line. So now in my practice, I focus pretty heavily on helping clients monetize those tax credits and take advantage of other incentives in the bill, which is really shaping our industry. So with that, I'll turn it to Scott for a quick intro, and then we'll go around the room.
Thanks, Jaren. I'm Scott Zimmerman. I'm in the Energy and Climate Solutions group here in San Francisco. I actually started my career as a oil and gas chemical engineer, but have spent the last 15 years after that stint in the renewable energy and now all the other climate-related technologies focused on project development and finance. I actually just want to say also thanks so much to Molly and the Lawyers for a Sustainable Economy at Stanford for hosting this. We've been so happy to be able to support the organization and be one of those founding members that Molly mentioned. It's just an outstanding organization, and encourage you all to help them and/or take advantage of the resources that they're offering to this. Over to Nicole.
Thanks, Scott. Hi, Nicole Gambino. I sit in San Francisco with Scott, also on the Energy and Climate Solutions team. I focus on the tax aspects of the renewable energy financing transactions that our team covers. And in particular, more recently, very much focused on the IRA and implementing it for all of our clients. With that, I will turn it to Herschel.
Hi, everybody. I'm Herschel Ween, and I'm located on the other coast, giving some balance to our practice in the New York office. And I'm also a member of the Energy and Climate Solutions Group. I'm a tax lawyer, senior counsel. I've been practicing tax law for almost 40 years, and feel very privileged to be part of this group and to be participating on this webinar. Brandon?
Great. Thanks, Herschel. Very good, very nice to be here today with all of you. I'm Brandon King. I sit in Seattle with Jaren. I'm a tax associate. I joined the firm a couple years ago, and I support both our energy and climate solution team and our tax team with both IRA compliance, implementation, tax equity structuring, and helping clients of all sorts and sizes be able to efficiently monetize these credits.
Thanks so much, Brandon. So what we're going to do is we've got kind of a panel discussion style conversation today that we're going to go through. First, we're going to kind of set the scene and talk about some of the history and how we got here. Nicole will give us a very brief, high-level kind of orienting overview of the new direct pay and transferability regimes. We'll go into a panel discussion from there, and then we've reserved time here for Q&A. So I already see a couple of questions. Definitely encourage you to submit as many as you can. We may or may not be able to get to all of them today, and so what we're going to do is do our best. If there are questions that were asked that we're not able to get to, we will endeavor to answer those and follow up. We have a slide deck today. We will send that out afterwards, along with some links and resources from the Wilson team about the IRA and direct pay and transferability, and links to other public resources as well. So that's what's on the agenda. And with that, I'd love to turn it to Scott first. So Scott, you teach actually a class at Berkeley Law School. You've got on clean energy, and you've got a really broad view here. I want you to just give us a sense of the history of how we got here, put direct pay and transferability in context by telling us how tax credit monetization has worked up until this point.
Yeah, sure, Jaren. So historically, the primary incentive for the renewable energy industry in the US has been provided through the tax code. And you might kind of wonder why is that? It's actually not just the renewable energy industry. Low-income housing actually was also generally incentivized through the tax code as well as other industries. And it's really because there's probably a longer discussion, but in general, it's generally easier to reach consensus in Congress to provide funding for a tax cut than it is to appropriate cash to make direct cash payments to industries and to individuals, even if the net result to the U.S. taxpayer and the government is exactly the same between a tax credit and a cash payment. And so just kind of easier to reach that political alignment. This incentive structure that we've had has been an enormous success in the renewable energy industry in the US, and it's really responsible for incentivizing virtually all of the renewable energy projects that we've had over the past decades, but in particular the last decade. However, it has quite a few very important drawbacks. The first is that project sponsors are generally not able to efficiently utilize the tax benefits, just given their lack of income. And so it's generally been major financial institutions that have made the bulk of all tax equity financing. There's actually only about 24 or less tax equity investors that have been active in the market over all these years and who've been responsible for that. There have been a few corporates here and there, but mostly banks. The other reason is it's just relatively complex and therefore quite expensive and time consuming to set up the financing structures to monetize the tax benefits from those investors. And really, the third and most important for this webinar and kind of what's bringing us here today is that the incentives are provided because they're in the form of a tax credit or other reductions in nonprofits and tax exempts have generally been unable to directly take advantage of these benefits. And so the direct pay and transferability regime was really designed to open up the ability of nonprofits and smaller for-profits and those maybe less able to organize large tax equity financing structures and that to be able to take advantage of these benefits and really spread the incentives out and enable additional investment and activity in this area. And I think that's partly why I think that's why Molly wanted, kind of reached out to us and wanted us to talk about this kind of this angle, because LSE at Stanford is so focused on startups and new business models, and not nonprofits as well, who are trying to really address climate problems. And so some of these rules, both as enacted by Congress, and also as we're seeing in the regulations, are really helping to do that. And we're going to talk about some of the challenges and opportunities as well around that.
Great, thanks so much, Scott. So we're going to turn it to Nicole, and Nicole's going to give us just, as I said, sort of a quick orienting overview of direct pay and transferability. So over to you, Nicole.
When are we going to put the slides up? Thanks. So touching on what Emma said, the most important piece of the IRA, which has been the most significant step thus far in advancing clean energy and having a sustainable economy, is the fact that we now have a 10-year window, and it could actually go even longer than the 10-year window if we have not met the emissions goal reduction of 75% or more by 2032. So just having this stability provides for sustained long-term investments. It's going to propel billions of dollars into development of new projects. We've already seen so much development just in the last several months. As more guidance is coming out, we're seeing more and more transactions. So it's really having this long-term window just allows for so much more development. When I first started practicing, we were still in an environment where every few years the PTC or ITC would be up for expiration, and you would be waiting for extenders or waiting for other ways for it to be extended along for a year or two. And it really, you have all these stops and starts in development. So allowing for this 10-year period, people can take on longer term projects, and it really just gives us a lot more forward-looking feasibility. Do the next. Thank you. So as far as direct pay and transferability go, they are new concepts brought in by the IRA. Some of you folks may remember back in 2009. Some of you may not be as old as some of us on the call, but back in 2009, there was a grant program. That was the only, the closest thing that we had previously. And this really just opens things up a lot more to having all of these credits on the list here are eligible for direct pay. All of them are eligible for transferability, direct pay, and then some direct pay for for-profits. We'll get into the specifics of that. But the regimes apply to renewable energy generation, including the existing PTC and ITC, as well as the going forward, the tech neutral PTC and tech neutral ITC, and then the new nuclear PTC. Carbon capture is covered by this, clean fuels, including hydrogen and things like sustainable airline fuel, manufacturing under 45X, as well as, which is a production manufacturing credit, as well as 48C, which covers the manufacturing facilities, and 30C, which covers EV charging. So the transferability regime means that you can sell these tax credits. Previously, to claim a tax credit, you needed to be the owner of the project to be able to benefit from the tax benefits, as Scott was talking about, which led to the development of the tax equity industry. Under IRA, you can actually sell these credits between unrelated parties. The buyer can't resell the credits, and you can't transfer depreciation, but it really opens up the market quite a bit to be able to finance these projects by people who can't otherwise use the credits. Under direct pay, there are the applicable entities such as nonprofits and governmental entities can apply for direct pay of all of the 11 credits previously listed. And then specifically for 45Q, which is carbon sequestration, 45V, hydrogen production, and 45X, which was the advanced manufacturing production credit. Those are, you can elect. I think we're going to leave. There's some key takeaways here that we plan on hitting on as we go through the panel discussion, but we left those in there for folks for future reference as well.
Thanks so much, Nicole, for that. I'm I'm going to open this up now to Brandon, Scott, and Herschel to give us your take on basically what does the new direct pay and transferability regime represent for the industry and specifically for private sector participants. Nicole just went over the kind of list of all credits that are eligible for direct pay and transferability, but there's obviously some very specific caveats with respect to private entities and early stage startups.
I guess I'll jump in. This is on the question of what the impact will be. This is a revolutionary tax act in the sense that I believe this is the first time under the federal tax code that we now have the ability to just sell pure tax credits. In the past, when you wanted to effectively transfer tax benefits, you needed taxpayers to invest in a project, which, as Scott was describing before, can be very complex. Now you can just have a pure sale of tax benefits, something unprecedented. And I'm just going to briefly tell you, I think it's going to have an impact on 3 different groups of players who've always played a role in these deals, but it's going to grow and expand the universe of all 3. First of all, sponsors. Now that there's a new potential source of financing for these projects, you're going to have more sponsors, more projects, because they'll have more access to more financing through the sale of credits or direct pay. Second of all, you have the other side, which are taxpayers. As Scott mentioned, in the past, the only real taxpayers who could invest in these projects were generally banks or very sophisticated institutions, because they had to really understand the nitty-gritty of the deal because they had to be part owner of the project. Now, with the new act, it's going to expand the universe of utilizers of tax credits to a whole new population of buyers. And then third of all, another group, a little bit under the radar until now, but I think you're going to see much more of them, are the financial institutions, such as insurance companies or financial guarantee companies, who are going to play that middle role of bridging the buyer of the tax credits with the sponsor and perhaps wrapping the credits with an insurance policy so that buyers who don't have the sophistication won't have to do the kind of due diligence that they just don't have the expertise. So I think you're going to have all these 3 sort of parties. We're going to see a lot more participants, sponsors, taxpayers, and these third-party financial guarantee companies or insurance companies.
Great. Thanks so much, Herschel. And Brandon, Nicole, any other thoughts on that? Great.
Well, I'll just jump in. I want to kind of reemphasize something Nicole said, which is all the different industries and technologies, and even moving towards this technology neutral PTC, which even is a catch-all for anything else that isn't specifically identified outside of those specific technologies. Everything up until today has been focused on just solar and wind, geothermal. There's been a list of technologies that's relatively short, with a little bit of expansion where you could bolt on storage to solar, for example. But the ability now to do standalone storage, which is a huge one right now, but then moving into all those other technologies, from EVs and EV charging and everything else is just, it's really the idea, and hydrogen, of course, we're waiting for the rules there, but like this really creates much more of an incentive, more complexity too, but the idea being to really help, not just just really help these new industries, new technologies get off the ground. And so if you're developing a new business model or technology in some of these other areas, you just have to think about the tax benefits, just like you have to think about grants, just like you have to think about everything else that you can do to bootstrap to get your company kind of competitive, frankly, to be competitive with everyone else. It's the ones who are taking advantage of these extremely lucrative credits and opportunities are the ones who are going to have a leg up.
Awesome. Thanks so much, Scott. Nicole, I see you took yourself off mute.
Yeah, I was just gonna pile on what Scott said. I think that is truly one of the most exciting things, in addition to just the runway, the fact that we aren't being prescribed what specific technologies are going to be eligible, and we're not defined, there are so many opportunities for new businesses out there to just develop new things that people haven't even thought of, and they will have these subsidies.
Great, thank you guys. So I want to get into detail now about specifically the tax credits there that are direct pay eligible for for-profit entities. So those are 3 credits. That's 45V, the hydrogen production tax credit, 45Q for CCS, and 45X for advanced manufacturing. Brandon, can you give us a high-level overview of those credits and how for-profit entities can be eligible and utilize them?
Yeah, happy to, Jaren. So I think just starting out, it's important to know, because we often get questions on this, why these 3 credits? So I sometimes refer to these as the angel credits, because they're even more valuable, because these are the 3 credits that tax-paying entities can receive direct pay for. And I think the main reason is that there was a perception that there was additional stimulus needed for these industries in particular. So kind of just ticking through the credits. So we have the 45Q credit for carbon capture, use, and sequestration, which was an existing credit, came out in 2008. But I think for anybody who's really familiar with the carbon capture space, that credit really didn't get any ammunition until about 2018, when the credit was significantly revamped. It was kind of just sitting out there. And then in the last few years, there's been, because of various changes to the statute, even before the IRA, has started to come into its own. But I think there's a perception that, at least for that credit, that carbon capture technology is expensive, it's very capital intensive, it certainly needed more stimulus. And then we have the 2 new credits, 45B for hydrogen production. Of course, anybody who's in the hydrogen space knows how expensive it is to set up a hydrogen production facility for an electrolyzer and other equipment that's needed. It's very expensive. And then the 45X credit for advanced manufacturing production, for manufacturing components, energy components of different projects as well. Another new credit that in many cases, either that production wasn't already taking place, or again, needed an additional stimulus to really provide a credit on a per unit basis. So I think that's the basic reasoning for why we needed the additional stimulus for those 3 credits in particular. Now, as Jaren said, these credits are even more valuable because, unlike the other credits that were mentioned on the slide earlier, tax-paying entities can elect direct pay for a limited 5-year period. So that would mean for the 45Q credit, 5 of the 12-year period that you would otherwise be able to get for the credit, you can receive direct pay. And then for the other 7 years of that credit, you could either monetize it yourself, or you could transfer and use the transferability regime to sell those credits. For the 45V credit, that's a 10-year production credit. So you would have 5 years of direct pay, and you could sell the credit for the other 5 years. Same with the 45X credit as well. So even more options to consider there, because now you can model the benefits of receiving a cash payment for the upfront portion of that credit period, and then selling the credit for the back end as well.
Great, thank you so much, Brandon. Could you also give us a high level of the actual mechanics of electing direct pay? We'll get to this a little bit later too. I think when we are kind of our last set of questions is around the latest status of the regulatory implementation and guidance that's been released. But how does one pre-file? What is the expected timeline? What do people need to know for actually going and electing it?
Yeah, so there's going to be a lot of steps, and to be clear up front, we're not sure exactly how the timing of this is going to work out. We of course get lots of questions of, everyone wants to know, when will I receive, if I elect direct pay, when am I going to receive the payment? And short answer is we don't know at this point, but there are a number of steps that we do know that have to be completed in a timely fashion to get direct payment. So the very initial step is a pre-filing registration process. This is what's provided in the recent guidance released by Treasury and the IRS. So any applicable entity or a tax-paying entity that's electing direct pay for those 3 credits I mentioned has to complete a pre-filing registration process. That happens electronically through an IRS electronic portal. That portal is not yet set up, but it will be soon. And they must complete that process in accordance with instructions that will be provided by the IRS. And what that does is provide what's called a registration number that is assigned to a particular facility or a project. It depends on the type of credit you're claiming. That will determine whether the credit is assigned to a particular facility or if it's assigned to a particular energy project. It's important to note that registration number is only valid in the year you obtain it, but it can be renewed in subsequent years. So, and that's also a time when if you need to update your information or just provide an attestation that your information has not changed. So it really all starts with that pre-filing registration process. And then in terms of actually claiming the credit or using the process, that would be done on a tax return. So there would be, you would file you would elect direct pay on a tax return. And it's important to note that that election can only be made on an original return that is timely. So it would be on your original tax return for whatever tax year you're intending to claim to which the credit is attributable, and or on an extension. You cannot make a direct pay election on an amended return, revised return, and there is no relief for that. So it is so important to make sure that the direct pay election is made timely on the original return. It's kind of a one-shot deal because if you miss it, you're not going to get it essentially.
Great, thank you so much, Brandon. Nicole, Herschel, any other thoughts on that before we move on?
I'm thinking we might be getting into this later, but the only other thing I would say, I'm just on what Brandon was just talking about, is once you make that election, it is generally viewed as irrevocable, although you do have one time to take it back. But once you take it back, you can't elect back in. So if you decided in year 3 you didn't need direct pay anymore, you can take it back, but you can't go back in and say year 5.
Great, thanks for that, Nicole. So now I want to talk about just sort of general project finance principles here. I think maybe Scott, we'll start with you. Can you talk us through some of the trade-offs you might expect for utilizing direct pay, how people might think about structuring this? Again, given that, as Brandon overviewed for us, it's only eligible for for-profit entities for these 3 credits for 5 years. So can you kind of talk us through what you see the pros and cons of using traditional tax equity, combining of direct pay and transferability and so forth?
Yeah, maybe I'll start off and let the tax experts turn this into something more positive. But I think one of the things that we find ourselves somewhat left with in kind of the vast majority of the applications where direct pay works is what maybe we were hoping for, more of an ability to have nonprofit and for-profit partnership partnering and utilization of direct pay in those instances. I think we're finding that the way the rules are shaking out, that there's probably going to be less ability to do that than we thought. And so, as an entity that would be eligible for direct pay, thinking carefully about how to structure deals in such a way such that you maintain the ability to get the direct pay and the benefits associated with that. Make sure that doesn't interfere. You're always probably going to need to partner in some way with a for-profit to get a project built to access a certain community, maybe low income or whatever. But you have to be pretty thoughtful about how to structure that partnering, partnership and how the for-profit is involved in it, such that you can fully kind of maximize your ability to do direct pay. But maybe I see Brandon nodding. Maybe he has some thoughts on that.
Yeah, no, this is just it's a critical area, and to be frank, this was kind of a big, not a little, a big letdown in the guidance, was the limitations that the direct pay and transferability guidance placed on partnership structures, because they really just took a very bright line approach by saying partnerships themselves are not allowed to make a direct pay election on behalf of their partners, even if some or even all of the partners in that partnership are applicable entities, or if it's a partnership that's intending to claim one of the angel credits, it's tax-paying entities. They really just left no flexibility there. And the only real out, which I think we all agree is a pretty limited one, is if you were alluding to, is just a co-ownership structure. It's not a formal partnership for tax purposes, but just a co-ownership structure where you have some kind of investment or partnership between, say, a tax-exempt partner and a taxable partner that has an economically similar structure through something that would be like a series LLC or some kind of undivided co-ownership structure. There's a lot of complications with that. And obviously, historically, in energy, that's not really what's been used. But as you said, their careful structuring is needed. And I think from a policy perspective, it's kind of a letdown, because by prohibiting, to me at least, prohibiting partnerships from making that election on behalf of, with otherwise eligible partners could very well exclude and prevent, private foundations, public charities, pension funds, other such entities from really being able to play in this space as well. And the other thing, and I'm sure Nicole and Herschel could speak more to this, I think it really does place even more limitations on those kind of entities if you have like a mixed partnership structure, because of the so-called tax-exempt use rules, which in other cases would reduce a credit that's owned by a mixed partnership, where you say have some taxable partners and some tax-exempt partners. So with those existing rules in place and the prohibition on direct pay for partnerships, unfortunately, the guidance unfortunately does place quite a few limitations.
Yeah, and I mean, I will say, there are reasons for those limitations. One could say, well, just to reduce the tax expenditure by the federal government maybe was one of the reasons. But I mean, to be more serious about it, there's also very, very good reasons to ensure the taxpayer money is being spent well. And so, it's just important to be aware of the complexity there. And one of the other complexities that's quite important when structuring capital, in these industries. I actually was just looking at the questions we have coming in, and there's a lot of them, so I don't know if we'll get to them all, but there were a couple of questions on sustainable aviation fuel, for example. And it actually just brings up a good point. There is a SAF credit, 45Z, I think it is. But if you think about sustainable aviation fuel, well, what is that? How did you produce it? Did you also do sequestration of carbon, geologic sequestration, which would also, potentially, you'd have the 45Q credit? Did you do, there's a lot of credits as you look at producing something like sustainable aviation fuel or hydrogen or something else. There may be a whole bunch of steps, and I think we're maybe going to get to these questions too, but making sure that, well, it's partly the way the rules are being developed, but then also following those rules such that you're not effectively double counting, right? And in some cases, maybe it's okay to double dip, and double dip always sounds bad, but get the access to multiple tax credits or multiple incentives. But what you don't want to, what the government's trying to do, and you're generally not going to be able to do, is double dip, like on the same reduction of a ton of carbon in a process. You're not going to be able to probably take two different tax credits that basically is tied to a single reduction. And that's very important, because you have, in sustainable aviation fuel, just to use that example, like you've got probably a bunch of different technologies that you're chaining together to get from a starting point of a feedstock to an ending point of a fuel that's being used. And there may be different ways to finance that and different ways to extract tax benefits from it. And so again, structuring that is really, really important, such that it works, and that because you're gonna have different companies doing different pieces of that chain, making sure that that basically all holds together.
Yeah, it's a great point, Scott. I want to pivot to the trade-offs and transferability specifically, because you're noting there's, it writes this sort of smaller universe of for-profit entities being eligible for direct pay, but then of course transferability is a much wider universe of credits. On the specific trade-offs on transferability, which is just selling credits. Brandon or Nicole, can you touch on like who, and I think I saw a question come through on this, who do people sell these to? What is the market looking like? It's obviously new, but can you tell us like how one literally goes about finding someone who will sell these credits if somebody's going to think about actually engaging in a transferability transaction?
Absolutely. And one thing I do, just based on the questions that are coming in, one thing we should clarify as well is just the entities like governmental entities, nonprofits, tribes, those folks that are eligible for direct pay, that not the folks that are electing and that we've been talking about. But if you are a direct pay eligible entity, you are eligible for direct pay. You can't also sell credits. It's those entities specifically are not part of the transferability regime because the view is you're going to get a check from the government. And as Brandon touched on earlier, there were some structures that we thought you might be able to chain direct pay and transferability together in doing these, either an inverted lease structure, for example, or different things. And the regulations make very clear that there are two kind of regimes there. So to get to your actual question, Sharon, we are seeing a lot of, new startups in this space popping up that are pairing buyers and sellers, doing the diligence on the projects to help facilitate these transactions. We're also seeing a lot of the traditional tax equity players looking to become syndicators of the credits as well. So there are plenty of folks out there, insurance companies, others that are helping to broker the credits, because part of the rules that came out in the guidance were the way that the passive activity rules apply to the purchase of credits. The buyers of the credits, it's going to be treated as passive to them. So unless you are a high net worth individual that also has a lot of passive income coming in, and the same goes for other partnerships and people that you might think would want to buy these credits, might not be able to utilize them. So really the folks that are buying these are more folks that are corporates and other entities that have a tax base to offset the credits.
Super helpful, Nicole. And can you also touch on the trade-off of lack of accelerated depreciation as well? Yeah,
sorry, I forgot there was a trade-off part of that too. So traditionally in a tax equity structure, you would have a partnership between the sponsor and the investor that comes in. They form a partnership, they own the project. The investor is disproportionately allocated the tax benefits. So they get all the accelerated depreciation, or most of the accelerated depreciation and the tax credits, in addition to some cash. In the transferability regime, the accelerated depreciation does not transfer with the credits. So the entity that is selling the credits is left with the depreciation. And as we said at the outset, that might be an entity that actually can't utilize the depreciation because they really aren't making money. But so that is one of the trade-offs, is you aren't able to kind of monetize that benefit, which, depending on the investor, is, they sometimes give some value, they sometimes don't give a lot of value. So you might not be leaving that much money on the table, but at the end of the day, it is not getting monetized. And just other things to think about in the transferability space is just the recapture risk lies with the buyer of the credit. So, we're seeing a lot of insurance products popping up to make sure that buyers are comfortable that, they will be protected if they buy an ITC and there's a casualty event in year 3, that they will, get the benefit of their bargain and still be able to, even if they have to pay money back to the government, they'll be reimbursed for that.
Great, thanks so much, Nicole. And then one more question on trade-offs before we move on. Back in the direct pay space, we've had some outreach from clients, particularly on the pro bono side, who write for eligible entities more broadly for direct pay. Thinking about, we touched on this a few questions ago about basically the potential lag time from the time you would file, you do your pre-filing registration, you receive that number, you elect it in your annual taxes, and then by the time you get it, could be 18 months or something. So people have been kind of talking about the need for bridge loans, kind of short-term financing. Nicole, can you talk a little bit about, or I'll open this up to the panel too, kind of what those needs might look like?
Absolutely, Jared. And to your point, I mean, if you're looking to these subsidies as part of your capital stack to build a project, but you are looking at this lag time, you are going to need a way to borrow against that in the future if you are dependent on that money. So we are seeing, some bridge loan products popping up.
Frank.
Marshall, Scott, right? And feel free if you have anything to add
Yeah,
on
I mean, the lag time creates quite a dilemma. I mean, for tax exempts applicable entities, obviously there is no choice. The only way to go is direct pay. They can't sell the credits. They're just going to have to live in that world and get the bridge financing to develop the project. Just to make clear to everybody, the lag time is from the time you file until you actually get the refund from the government could take a long time. We don't know yet how long that will be. People are making comments how it should be expedited in different ways, but so far, the classic refund process could take a very long time. The dilemma would also be for profits on the 3 credits where you could get direct pay. It could actually make more sense to sell those credits, even though you're going to have to sell at a discount. Let's say you sell it at 95 cents. I'm being optimistic here for the sellers. You're going to do a lot better selling at 95 cents versus going for direct pay and waiting 18 months, if interest rates are 8-9% a year for the relevant taxpayer. So it could be, in many cases, transferring will make more sense than going for direct pay on those 3 credits. So there are a number of trade-offs. And as we mentioned, with depreciation, we're hearing that from a lot of clients. And the last trade-off I just quickly mention is, maybe we'll get to this later also, it's a lot easier to sell the base credit, the 30% credit, I'll call it, than selling some of these adder credits. So for example, the domestic content credit, that's a very hard credit for a buyer to assess, to do diligence. And even for insurance companies, it's going to be tough. So the question is going to be, are you really going to get a good price on the market for that if you try to sell it, as opposed to bringing the tax equity player who's ultra sophisticated and has the ability to do that kind of due diligence? There still may be a little bit of a better pricing on that adder. Again, these things are in flux. The law is developing, as Molly mentioned at the outset. Hopefully the final regulations will give us an easier path to get comfortable on these adders. But right now, I think that's an issue also for the transferability market.
And I think just to highlight, Herschel, I think underlying what you're talking about on the adder front is the existing regulations or the proposed regulations that have come out require that you sell kind of a proportionate amount of the adder with the base credit. You can't kind of peel those away. So if you are going to be a buyer of those credits, you do need to diligence any of those adders to the extent they're going to be claimed.
And just a little good news. We've had some positive feedback. Nicole and I helped write a comment letter asking the Treasury to change the rules to allow you to sell the credits separately. I just want to sell the 30% credit to you, the 10% credit to you, etc. And we've actually had some positive feedback in the sense that they're asking how would they do that? How would you propose the rules would work? So my gut is that they are very interested in making this change, and let's hope they do so.
Yeah, I guess one helpful thing what you can do now is, although you're not permitted, as Herschel said, to do what we call vertical slicing to separate the base credit from the adder, you can do horizontal slicing, meaning for the entire credit amount, you can transfer part of that, retain it, the rest of it for yourself, or you could have multiple transferees. You can do the entire credit amount. You could have many different transferees, certainly. So there's certainly flexibility on that front. I guess one other wrinkle, and I say wrinkle because we don't really know how this is going to work, is with respect to projects. I'm specifically thinking about projects that are claiming Section 48 ITCs that would be eligible for the so-called LMI adder, which is either a 10% or a 20% adder. That adder works differently from the other adders, the domestic content adder, the energy communities adder, because that's an allocated adder. It's awarded, and we don't know what the timeline is going to be for the actual awarding of that adder by the IRS. So you can imagine a scenario where you'd have a project that's placed in service in year one, and a taxpayer could say transfer the base credit in year one, but they might only be awarded this adder in year two following the application process. So that raises some questions, both in terms of when would you get the credit? When would you get the base credit? When would you transfer that? When would you get from a procedural perspective? I'm thinking, do you need one pre-registration number for the base credit? Would you need another one for the LMI adder? There's procedural issues there, and then just timing too. To Jaren's point, how do you when you're trying to finance that? How do you're financing the upfront portion, say like the 30% credit portion, but you're not sure how to do the 10 or 20% LMI adder because it could be well after the fact. So again, we don't know the answers to these questions, but for those who are thinking about the LMI adder, I think there's some additional considerations to look at as well.
Great, thanks so much, Brandon. Yeah, really appreciate your thoughts on the trade-offs, because there are some, right? Like the direct pay is an incredibly powerful incentive. I mean, I can say when we were on the Hill and drafting this, the old ARA era, the 2009 financial crisis, the stimulus bill, and the creation of this 1603 cash in lieu grant program at Treasury. It was kind of modeled off of that design, and basically intended to work similarly to a grant program, but that doesn't mean that there aren't trade-offs with the lag time. And so basically, I think what we're trying to hammer home here is that there are lots of different considerations in looking at your total weighted cost of capital and how that's going to play out in any individual project. So 2 more questions here before we'll shift to try to answer as many of the questions as we can in the Q&A. This next one is quick, and then we'll go into kind of what the latest, we'll talk about basically some of the comments received in the request for comments for direct pay and transferability. But first, because we've got early stage companies here on the call, a lot of these companies have applied and are recipients to DOE direct grant awards from the IRA. There was obviously hundreds of billions of dollars appropriated to the Department of Energy, EPA, USDA. One thing I should say, just as we got a couple of questions, and it's very timely because it's the end of September on a government shutdown. I can say, having worked for a former appropriator who's now the chair of appropriations, so know more about federal appropriations than I probably want to. But one thing I do just want to make clear for those of you who might be feeling nervous about what happens on the grant side, the vast majority of the new programs authorized at DOE, which I think will cover most of the people on this call, those were appropriated in the IRA over what are called multi-year funding. So basically, they appropriated enough money in that bill to cover those programs for multiple years. What happens in a government shutdown and sequestration is that the accounts, the programs that are authorized that basically only operate if they get discretionary funding from Congress year over year in an annual appropriations bill, those programs can effectively shut down or be subject to sequestration. So, you might be familiar with a program like LIHEAP, that's the low income utility assistance program, some others that basically need annual appropriations. Those could be touched, and to be fair, the IRA did appropriate some funds into those types of programs too, but overall, I just want to calm some fears about DOE grant making. But with that said, would love to, for Herschel and Brandon, if you can talk us through basically credit stacking. So like, you're a recipient of DOE awards, you're also planning to utilize tax credits. And I should say a lot of these notices, these FOAs for a DOE grant making, they actually literally ask applicants to provide in their financial plan and other grant materials, like what your credit monetization strategy is, because DOE wants to be maximizing their grant making authority as well. Herschel and Brandon, can you give us basically the high points on credit stacking? What are some of the limitations? What are the considerations people need to take into account?
Sure. I'll just state the general rule, and then I'll hand it off to Brandon to get into the nitty-gritty. But as a general rule, Congress amended Section 118 in the 2017-2018 Tax Act And it used to be that when you had a federal grant, such as from the DOE, the old days, you could just reduce the basis of your assets that were funded with the grant. Now, because of that change to the code, generally speaking, grants are taxable to the recipient. So it will not reduce the credit. It won't reduce your basis, but you will have to take it into income. Unless there's something in the grant law that specifically says it's exempt, but right now I'm not aware of, at least the ones we're talking about, like the DOE, I'm not aware of that exemption being granted. So you will have income. And the second point, and then I'll hand it over to Brandon, is as a general matter, they don't allow you on one project, one facility, so to speak, to take two different credits. But there is some wiggle room on that. And Brandon, with that, I'll hand this to you.
Sure. Thanks, Herschel. I think one of the exciting aspects of the IRA is the new ability to pair different credits in different ways and to pair up different technologies for different outputs in ways that were not possible, both from just like a functional perspective and because we have these new credits that you're able to do. So there's a lot of flexibility to be able to pair things, and then there's a couple specific areas where you can't do things. So one area that is very exciting is being able to pair up solar, wind facilities. You can have co-located energy storage and be able to claim either a Section 45 PTC or a Section 48 ITC for those facilities, and say pair that up with a hydrogen plant. So you can have the output of the PTC or ITC facilities feeding their output to a power module, an electrolyzer to produce clean hydrogen, or green hydrogen, as we say, and be able to claim the 45V credit for the hydrogen production. So now you have two credits, and then you can even take that hydrogen and potentially use that as a feedstock for a methanol plant and produce methanol as an output and claim 45Z clean fuel credits. But note on that 45Z credit is only available for 3 years, 2025. It's not currently active through 2027. So that is one potential option where you could potentially get 3 credits in there. I'll just note, though, that it's an exciting possibility, but it does require careful structuring to make sure that the facilities are such that you are able to in fact maximize the credits throughout the entire process train, but there is still a lot of flexibility to do so. Now, there are a couple areas where you can't stack credits. One is the 45X advanced manufacturing credit and the 48 CAPC advanced manufacturing facility credit. So you're not allowed to claim, in most cases, a 48C credit for an advanced manufacturing facility and a 45X credit for the output of that facility. So for the energy components that are being produced by that facility. In most cases, you're not allowed to double dip, which I think just makes sense logically. Another area, and this goes back to the example I gave a moment ago, is that if you're looking to claim, say, the 45V credit and the 45Z credit, and in some cases, if you want to go the full route and add on, say, post-combustion carbon capture and potentially capture the 45Q credit, there it gets a little tricky because the 45Z credit would not be you could potentially get all 3, but in most cases you have to make sure they're in separate facilities. So you couldn't have a combined facility that would be able to claim all 3 credits. There are specific rules that say, for example, you can't claim a 45V hydrogen credit if you're also claiming a 45Q credit for carbon based on carbon capture equipment that's embedded within that facility. So I think my takeaway point here is this is very much a functional analysis, really looking at the process train, how the facilities are interrelated, whether they're co-located, and really understanding at a granular level how everything is flowing from start to finish.
Thanks so much, Ben. And that's a really good point on the advanced manufacturing. I've seen a couple of questions in the Q&A from manufacturers One thing we should say on the two, there's two credits that apply for advanced manufacturing. One, as Brandon mentions, 45X, the other is 48C. 45X, the way I like to think about them is 45X is it's extremely granular. So there's basically like a list of basically manufactured products that are eligible, and they get like very, very specific in terms of definitions of inverters, microinverters, you name it. And 48C, on the other hand, is functionally intended to be a catch-all. So basically, if the thing you make was not included in this list in 45X, 48C is sort of, there are technological categories, so that's definitely something to look into, but it doesn't have these sort of tight definitions. With that said, there was $10 billion appropriated for 48C. So I think Brandon mentioned the LMI adder before, and one, just global general, they're not capped, right? Like in general, they are not capped. You can, as long as you qualify, you meet the criteria, you follow the rules, you can get these. 48C is different. You have to apply for an allocation like the LMI adder and the ITC. And the latest round of announcements for that has actually closed recently. So there are $4 billion released under that program, but there's still $6 billion that will be released, sort of in the coming year or so, maybe a bit longer. But anyway, just noting that for the manufacturing folks on the call. Okay, so last set of questions before we go into the Q&A. So we're going to talk about the latest on the regulatory state of affairs. Basically, there were two proposed regulations, one on transferability, one on direct pay. So the first question I'm actually going to ask Nicole and Brandon is, can you actually talk us through, like, from a tax perspective, when we talk about, there's all these notices, proposed regulations, what can taxpayers actually rely on? Like, to tell us about what people should think about in terms of, relying on the guidance that's out there. They see, proposed regulations, they don't know what to do. Give us the like 101 on how to rely on this guidance.
Sure, Jen. So currently, as you said, we have the proposed regulations for direct pay and transferability. Taxpayers can currently rely on those proposed regulations when they become, they have been open for comment, they held a hearing, they will be finalizing the regulations. Once those get published, there'll be some period of time where you'll still be able to look to the proposed before, should be 60 days before the finals kick in. But once the final regulations are kicked in, then you must rely on the final regulations.
Great, thanks, Nicole. Okay, so now into what the proposed regs actually say. So we've talked a lot about the lag time, the pre-filing requirements. One thing I think in particular for the trio of credits that for-profit entities are directly eligible for, can you talk to us about what the rule says about the pre-filing process basically not being automatic, the potential risk for audit, what some of those pitfalls could be?
Sure, yeah. So the pre-filing process really, it's not clear yet. They haven't launched the portal. That's something we're very much anticipating the launch of. But, the idea would be you would submit your application and, you would get your registration number. And, that is, means you've submitted everything you needed to submit to get that number, but it doesn't necessarily mean that you are eligible for the credit. There's nothing to stop the IRS from then auditing you in the future. Whether or not the degree of overview before they issue those numbers, I think is still an open question, is how much digging they're going to do at that stage. But they've made a point of saying that just because you have gone through that pre-filing process does not mean that you necessarily will get a credit at the end of the day.
Great. And, we just finished up talking about how, the vast majority of the credits are not, they're not capped. At the same time, the direct pay process, can you be denied? Can you basically fill out all of the required paperwork and be denied? What does the rule say about that?
Brendan, you're nodding your head. I'm going to let you take this one.
Yeah. Sorry, I was having trouble with the unmute button. So the short answer is yes, it can be denied, but we don't know what this review process is going to look like. So we've gotten questions about, what kind of process is the IRS actually going to use? Is it going to be like a mini audit? Is it going to be kind of like, yep, this looks good, and you can claim it? It's not clear at this point. And there is concern about lack of remedies for taxpayers who say their registrations are rejected and they're not actually allowed. Because the IRS has broad authority. They can request any other information, as the guidance says, that it deems necessary. So in theory, it could even withhold a registration number until after a return's due date, for the tax year for which the credit is determined. That could actually prevent the election. I think that's a significant concern. So it's not clear in terms of what the scope of the review, so they certainly could deny. Another thing is there's no real procedure for appealing that as well. That's not baked into the guidance. I think that's something we'd like to see, as some kind of appeal procedure to allow taxpayers to challenge that at the IRS level, instead of just being outright denied.
Great. Thank you, Brandon. Okay, let's go to panel. Electric pay, but there's, the IRS determines there was what we call an excessive payment. What are the consequences?
Yeah, so if there is an excessive payment that the IRS determines, then the general rule is that the tax liability, so whatever the tax liability would be, is increased by 20%. So essentially there's a 20% penalty if the IRS determines that there is an excessive payment. Just note for transferability purposes, if you have a credit that's been transferred, that excessive payment falls on the buyer of the credit. That's a very important point, does not fall on the seller, which means having adequate contractual protections and indemnities for excessive transfers is going to be absolutely important when you're structuring these deals. Now, there is a reasonable cause relief, and the IRS provides some guidance on that. I think the most important factor there is the extent to which at least in a transferability context, the extent to which buyer did their due diligence and relied on documentation and other information provided by the seller. But we, still don't know like all of the nuances and how exactly that's going to play out. But it is there, the reasonable cause relief.
The consequence of this, I just think, is going to be that buyers of credits are going to insist on financial guarantees and insurance policies. Unless the seller of the credit is a well-known big company with a tremendously rich balance sheet, I don't think people are going to buy the credits without it. So in terms of sponsors who are looking to sell credits, I think you're going to need to look to sort of a middleman who has that access or will provide those kind of guarantees, that kind of insurance, in order to bring the credits to the market.
Jaren, maybe there's a few questions actually, and that maybe this kind of follows on Herschel's point a little bit that I can try to address here, which is a few people have asked about kind of how do startups get access to these incentives and tax credits, and there's a question about kind of what's the market, is there a defined marketplace, and this sort of stuff. And I guess there's just to give a little bit of background, and this is just taking a step back a little bit. The tax credits are, so I'm talking about now really for profits and not really the direct pay regime, but for in the transferability or just ability to take the credits yourselves. A startup company, if you build a project that is eligible, and that's dependent on the specific technology and placing it in service and all of that, you will be entitled to that tax credit. Of course, startup companies don't pay taxes. They spend a lot more money than the revenue that they take in. So if you don't have any revenue and you therefore don't have any income, you don't have any tax liability, and therefore the tax credit is not useful to you right now. And so you can carry it forward for some number of years. It's quite a while, maybe 20 years. Tax people know this, but like you can carry it forward, but each year it basically devalues. You just carry the dollar forward until you can use it. And it might be 5 years or 10 years before there's really an ability for you to have revenues and income that you can take it against. And so This regime does enable you the transferability. The idea is that you can transfer it and get paid right now. You get paid some number of cents on the dollar. You know, but this also just another challenge that you have to keep in mind is, yes, you can go out and sell it. But as Herschel just said, if you're a startup company with effectively no balance sheet, what's the buyer going to pay for that? What risk are they taking? And in very well-established, de-risked markets with established tax equity buyer, investors and credit buyers, they probably will shy away from these, from a startup, because you don't have the balance sheet, as Herschel was just saying, to stand behind it. Now, maybe a market will develop where a startup where things are a little bit questionable or whatever, maybe you can get a 10% or 20, well, 10% is kind of where we are, but like maybe you get a 20 or 30 or 40% discount. So someone will pay 60 cents on the dollar, but then what is the risk that's really being taken there? Is it a risk that the startup really wasn't eligible? And then does anyone really want to take that kind of risk with the IRS? I don't know. It opens up a lot of questions. I don't know that we should assume that you'll be able to just sell it, right? If there's really some question around whether you or not, you're really eligible to sell it to it or not. So I think it's not quite like a normal market where just, a car happens to be used or whatever, so it goes for a lot less. It may just be kind of more of a black or white thing. I just again, even taking a further step back, because there was at least one or two questions on this. When we talk about what is the market, how do buyers and sellers match up, which is what we've been talking about this whole time in the transferability space. Whether the IRS comes up with some kind of a system to track that, we'll see where it goes. But there are a lot of companies out there over the last year that are trying to set up these marketplaces and trying to really help connect buyers and sellers and create platforms and all of that. And so I think there already are a few of them out there, and a lot, probably others that will innovate and develop. But really what we're talking about right now is literally just somehow a project developer gets in touch with someone who has tax liability, and that's what we're talking about when we say there's a market. Market means there's two people who are ready to transact, but there really isn't any single place that everyone is going, or that everyone could go to see what's available or anything like that. But that's what, again, there's a lot of companies trying to fill that gap, to make it just reduce the friction, reduce the overhead associated with matching up people. So you can have a bunch of maybe small buyers for one big project, or the other way around, a bunch of small projects selling credits to one big buyer. And those kinds of transactions are very, very expensive and difficult to broker or facilitate right now because, because there's just too many people, maybe one side or the other, not being that sophisticated. So that's a really kind of exciting area that keep an eye open for companies that are trying to solve that kind of problem.
That's great.
I've been in contact with brokers and with insurance policies backing it up, who are telling me they have the buyers, they're actually looking for the sellers. And it seems the insurance companies are willing to do the due diligence on a lot of these sellers. Even if you're a startup, even if you don't have a great balance sheet, they'll look at the project and I guess get comfortable enough that they'll provide that sort of financial backing so that buyers will be comfortable. So that's very hopeful, and will help small and startups and new sponsors.
Yeah, those are great points, Scott and Herschel. And yeah, like we mentioned before, starting to see some startups pop up in the space, some of whom we've worked with. And so, if there are, please feel free to reach out to us for questions if you're kind of looking, trying to find players in that space. So with that, I think given timing, I want to go over to the Q&A that we've received so far. So one collate on a monthly basis, all of the different current funding opportunities across the Department of Energy, EPA, and especially within the Department of Energy. As some of you might know, it's actually quite a difficult thing they're not all listed all together. USA Jobs is not always kept up to date. It's a little bit difficult to search. So it's a public resource. You don't need to be a client to use it as public facing. And it's just trying to get the word out about the funding opportunities that exist for your capital stack. So with that, I will say thank you to my team, and I'll hand back over to Molly.
Okay, thanks so much. I just put the screen up. You'll see on the slides that are shared that there are some key takeaways here that Wilson wanted to provide. We are out of time, so I'm not going to have them go through them, but you can read them and let us know if you have any questions. Just really quickly wanted to touch on how entities might apply for pro bono help for the Lawyers for a Sustainable Economy initiative. But before I do that, there were a couple of questions about whether we'll have any information for how tribal entities can access Inflation Reduction Act funding. And we actually just completed a three-part webinar series for tribes, and those recordings and slides are available on our website listed here. And actually, Jaren did another webinar with Lawyers for Good Government that was really focused on local government. So hopefully we have all those bases covered between those. So check those out. So here on our lawyersforsustainability.com website, we have an intake form. You fill that out. We follow up with you and find out a little bit more about your legal needs and try to assess, whether you're eligible for pro bono help. If you meet our pre-screening criteria, we connect you with a firm if they have availability. And ultimately, the decision about whether you're eligible for a pro bono is up to each firm to decide. And it's kind of analyzed on a case-by-case scenario. But just you can read more about that on our website here. And just really quickly, I want to thank everyone, thank the Wilson team and Emma for this amazing content. There have been lots of great questions, and we'll try to get answers to those as well. But a lot of the answers were integrated throughout the presentation. So hopefully, I think we've covered most things. And a shout out to the other firms in the initiative who provide support for the initiative and also do a lot of the pro bono work. So thank you, everyone, and everyone have a good rest of the week. Bye.
Thank you all.
Thank you.